Introduction. Until some point within the last year, my faith in the integrity, indeed the lawfulness, of the U.S. Supreme Court was in a sad state of disrepair, and had been for many years, in light of the obvious unconstitutionality of the income tax, as enforced against private citizens within the 50 states. The failure of the court to declare it so seemed an incontrovertible indictment. At the very least, respect for the rule of law demanded that the apparently incomprehensible statute be ruled void for vagueness. But for all the many years that this tax has been with us, it has been permitted to remain largely unscathed. Last year, my faith was restored. Well, that's actually far too strong a statement. The court still has much to answer for regarding the income tax and a good deal else, but as far as the constitutionality of that tax as written is concerned, all is well, for the IRC passes constitutional muster. How it happened. Since 1992, when ordered by a rogue and ignorant judge to comply with all internal revenue laws, by which was not meant comply with the law, but rather comply with the IRS, and the circumstances behind which are beyond the scope or purpose of this book, suffice it to say that they involved the tax protest. I have filed 1040s annually, a practice which had not previously been my habit. However, though coerced into producing the form in the typical fashion, I would not allow myself to be compelled to attest to what I knew to be untrue, and so always added to the perjury statement above the signature lines the words, except insofar as the term income is misused herein. This was a reference to the general and explicit presumptive characterization of all wages, salaries, and similar compensations as income on the forms and within the instructions. In 1992, I provided a page-length attachment to make this statement, then used the easy version thereafter. I knew perfectly well that such things, insofar as they have to do with me, cannot be taxable income, at least not unless I, by endorsing such a characterization, or letting it stand unchallenged, made them so. For 9 years, even after becoming free of this judge's dictates, this was the course of things. I, and eventually my wife Doreen, would fill in the forms, add the disclaimer, and send them in, and the IRS would keep a whole lot of money which had been withheld from my earnings during the previous year while paying no attention to my small but legally significant protest. After all, I had just had a taste, actually a pretty big helping, of the disdain which a federal district court judge and numerous attorneys on both the prosecutorial and defense side of the bar apparently had for constitutional limitations on the taxing power, and arguments based upon those limitations were all I was equipped to make. I was familiar with the work of others such as Lynn Johnson and Irwin Schiff, who had made some limited study of the tax code itself, but even their arguments still ended with the "it doesn't matter what the code says, you can't constitutionally tax me" conclusion, basically the same approach that I had taken with mine, which had no currency in the courts. Indeed, until the Cheeks case was ruled on by the Supreme Court in 1991, trial court judges routinely suppressed arguments based upon the constitutionality of the tax, and even in ruling that Cheeks' arguments had to be permitted, the Supreme Court itself declared them to be frivolous. Without such arguments, fighting it out in court seemed doomed, or at least an impossibly long shot. All of us faced the conundrum that the portions of the code that we had seen were ambiguous at best, and at worst seemed written in defiance of the Constitution. Furthermore, who knew what else was to be found within that maze of lawless nonsense that maybe was less ambiguous and against our position? So I bided my time, added my disclaimer, wrote my monographs, and continued to study the issue, more or less patiently. I intended to resume my more active disagreement with the government on this issue soon enough, but my 2 children had been born since the start of my last close encounter with a federal court, and I was willing to wait until I was really ready before going back onto the battlefield, but the bad guys wouldn't wait. In autumn of 2001, for some reason probably born in mindless, banal, bureaucratic perversity, though perhaps in recognition of my little disclaimer's nascent legal threat, the agency suddenly informed my wife and me that because of the disclaimer, it refused to accept our return for 2000. The IRS argued, in essence, that without the endorsement of its characterization of our receipts by an unqualified perjury statement, our return cannot be considered as legally filed. Not that it was illegally filed, mind you. It was treated as not filed at all. They sent us a perjury statement on an otherwise blank piece of paper and indicated that if we would sign it as is and send it back, they would incorporate it into our return and all would be well. If not, we would be considered in default. Our deductions and exemptions would not be honored, and interest and penalties would apply and grow. We had no intention of backing down on this point, and so I began an analysis of the Internal Revenue Code and other relevant materials far more intense and infinitely more productive than any in which I had ever engaged, thanks to the marvelous capabilities now afforded to such research by the technology of the information age. This time I could leapfrog about checking every obscure section reference, search the entire multi-million word document in seconds for every instance of keywords and phrases, and draw upon a huge volume of data on the subject posted on the internet by others similarly engaged. This time I could actually have the grotesque sprawl of incoherence on my screen in my own home. This time I actually read the damn thing. The end result of this research was the epiphany regarding the constitutionality of the code and the behavior of the Supreme Court to which I referred earlier. You will all be happy to learn that the court has been right about the lawfulness of the code, and so have I. Doreen and I have been able to file our last couple of returns with no clarification needed. When you're through with this book, you'll understand how. Cracking the code is not going to be an easy read. For one thing, there's necessarily a great deal of legal language in the form of statutes and judicial rulings. For another, many readers will find themselves learning that everything they thought they knew about taxation, and much else about the lawful relationship between citizen and government, is wrong, which is never easy, no matter how it is presented. However, I trust that the desire to know the truth, not to mention the 30 to 40% of every year's earnings which might be at stake for many readers, will provide sufficient motivation to press on when the going gets difficult. And I assure everyone that even if some portion of this complex material just doesn't seem to make sense initially, by the end of the book you will understand. The process of overcoming a vast body of multidimensional misinformation makes a purely linear exposition of the truth fruitless, if not impossible, and cracking the code is organized accordingly. This is not to say that a linear presentation of the taxing statutes cannot be made. The problem is that to understand the statutes which are written within a framework of constraints typically assumed by the writer to be known by the reader, it is necessary to understand those constraints as well. Some of these constraints are inherent in the principles of jurisdiction. Some arise from the rules of statutory construction, others are imposed by the specifications of the Constitution, and still more have evolved with Supreme Court jurisprudence. As understanding, or even just a sense of each of these diverse but related elements becomes incorporated into the reader's overall frame of reference, others which had seemed mysterious will become clear. It is worth noting that the very important benefit of this effect will best be realized if the book is read as nearly as possible without significant interruption. So hang in there, keep your eyes on the prize. You'll make it, and it's worth it.